Hey everyone, happy Friday, happy Finance Friday. This is the show where we help you transform your relationship with money and give you the tools to grow and protect your wealth. My name is Ryan Wilson. I'm here with Joey Coleman and Zach Lombardo with Woodward, Piers, and Lombardo attorneys. And super excited to have them today. And before we get started though, I do need to make an announcement. As you guys know, a couple weeks ago now, we did our second round of the 2019 Nova Wealth Management stock draft. And so I just want to give a quick update. So one of my picks was Tyson Foods, and I have sold them. So we get 5 trades between now and Christmas, and I used one. So I sold Tyson Foods, and I bought Lululemon. So just to give you an update, quick update, I believe. Give me 1 second. I'll let everyone know how everyone's doing. Just really quickly, we're only a month in now, but let's see. I know that Amy was doing really well, so we'll see how Jim and I were doing. Amy is currently up, it's loading, 4.15%, so that's pretty good. Jim is down 1.65%. He not really a good reason why. Heiko's kind of fallen a little bit, but I'm sure he'll turn it around. I have faith in you, Jim. And me, I am. Where am I? And I'm up 1.53%. So I'm in second place. Amy's in first, and Jim is slightly behind. But there's still a lot of time between now and Christmas. They both still have 5 trades. I now have 4 if we decide to get them moving. So anyway, today, now that that's out of the way, we're going to talk about intellectual property. We're going to talk about copyrights, trademarks, patents. And trade secrets, which are all super exciting things. Maybe I'm just geeking out a little bit, but I had a lot of questions. We were talking a little bit before we got on here, and I was like, there's just so many things that I want to know. And so hopefully you guys will find it entertaining today. But the first thing we want to get to is just what are the different types of intellectual properties. And so I'll let you guys kind of just however you want to order it, but you just give us a little quick update.
I'll kind of talk about copyrights and trademarks, and then Zach can kind of jump in on the other ones. So when you look at intellectual property, it's really kind of a regime of a different set of protections based on what you're trying to protect and how you're trying to protect it. When you're looking at copyrights, it's really more of the idea of an expression. Once you express yourself in what the Copyright Act calls a fixed tangible medium of expression, you now have a copyright. And so that's typically movies, books, it can also be computer codes, architecture drawings, architecture itself, dance routines, choreography, that kind of thing. That's all going to be protected by copyright. It's it's got to be fixed in a tangible medium of expression. It's got to be an original expression. It's got to be done by an author. Then if we look at trademarks, trademarks are brand recognition. It's a protection for your brand and making sure that others don't dilute your brand by having consumers be confused about what they are. So for example, Starbucks has a vested interest in making sure that other people don't get its brand confused with other types of coffee, because the last thing they want is someone to associate them with coffee that they don't want to be associated with, or tea, or another kind of drink. They want people to understand when they go into Starbucks what they're ordering and what they're buying, and they want people to associate good quality coffee or whatever quality coffee with Starbucks, with their brand. And so those are kind of how copyright and trademark work. And if we look at a lot of the top companies right now in the United States, as we kind of move from a manufacturing state of affairs to more of a technological state of affairs, especially after the information revolution, what we're looking at is those technology companies specifically, they have a lot of IP, a lot of their portfolio in IP. So when they're valuing their companies, they're valuing them not on just the human capital, not on just what they're making, but a lot of times based on the trademarks and based on the copyrights that they have.
So like, so trademarks that we know commonly would be like a Nike, right? Trademarks, the company logos would be the biggest example of a trademark, correct?
Exactly, and they kind of vary between different categories of trademarks and the amount of protection that they're afforded. So if we look at trademarks, Haagen-Dazs is a perfect example. When you have fanciful trademarks where it's not really an actual thing. Haagen-Dazs is not a place in Germany. It's not a place in the Eastern bloc of Europe. It's actually just a made-up name, and so it's going to be afforded the most level of protection. Why? Because it's the most unique. Followed by arbitrary, for example, Red Stripe beer. It's not descriptive. It's arbitrary as to the quality, the geographic origins of the beer, etc. It's just a name, so it's kind of arbitrary in that regard. And then the next level below that is descriptive. It's kind of given some of the weakest level of protection. So brown chair, blue chair, apple, red apple, that kind of thing, where it's just describing the product that you have. That's really going to be afforded a very low level of protection. And it also affects the valuation, because if you have a trademark with a strong level of protection, most likely it's going to have a greater valuation.
So that's trademark, copyright, and then
patents.
with patents, which...
Patents are most easily thought of as inventions. These
Okay.
are useful and novel concepts, ways to solve problems. And so these are, out of the pile of intellectual property, the most expensive to develop. And so the companies that you see that own a significant number of patents are pharmaceutical companies, and oftentimes what they consider to be their value is not the fact that they're able to manufacture the drugs, but the fact that they were able to engineer the drugs in the first place.
Right.
And the way they protect that is through the patent structure. And at this point, it's kind of helpful to understand how long all of these things last, because this kind of helps you understand the marketplace a little bit, especially in the pharmaceutical space. Copyrights, as soon as they're created, they last for the lifetime of the author and then an additional 70 years. Trademarks, which is a very long time, so the public domain does not start until 1929. So things that were written in the 30s and 40s are still under full copyright protection.
Okay.
Trademarks can last forever, as long as the brand keeps using it. Every 10 years, they have to file a statement that says, we're still using this, and in fact, here's a picture of our coffee cup with the logo on it. Patents expire. They're 20 years, and that's it. And so this is kind of, and you can see this in the marketplace. You can see pharmaceutical companies, there's only a name brand, and then all of a sudden there's generics.
Right.
That happens when the patent expires.
Yeah, so that's why, so a big one right now that's in the space is the little blue pill, right? And so you hear it on the radio all the time that there's all these generics, like a ton of them, because that patent then just has recently expired.
And you can also see this in other spaces, which is kind of interesting. So e-cigarettes,
Okay.
all of a sudden they came out of nowhere. You didn't see them. They were not something that was common. The next thing you know, it's all over the place. And what happened was there was a patent that expired.
Okay.
And it was critical to the technology in the e-cigarettes. And so patents, way more so than the other ones, drive the market because it allows people to protect what they're doing. And interestingly, it's not just protect it only if they're using it. So in the trademark space, you couldn't just lock up the phrase Starbucks and then never sell any Starbucks. You have to actually sell it. In the patent space, you can lock something up and hide it. And so this allows companies to do even more aggressive things. So for example, there was a series of allegations made when GM made the first electric cars a while back in the, I think it was like the early 90s. And all of a sudden, we didn't see electric cars after that. And the allegations that were made were the oil companies were going in and buying up patents.
Yeah, I remember hearing about that.
And preventing them from being used. And so patents are very, very powerful, and the ownership of them as a result is worth quite a bit. And then the last piece of intellectual property that is typically considered in the group is called trade secrets. So this is kind of like the redheaded stepchild of the intellectual property world. And that's not fair, because this is really the most common trade secret there is. This is the most common most common intellectual property that you're most likely as a business owner to have. These are things like customer lists and anything that you developed in your business that helps you do your business better than all of your competitors. These are things that are trade secrets. And as long as you take reasonable steps to keep them secret, you make your clients or your employees sign confidentiality agreements, or you just don't openly share these and push these on your website, these are trade secrets. And you can keep these forever. And probably the most classic example of a trade secret is the Coca-Cola formula.
Okay.
It's not a patented formula. That was the only thing. It could maybe qualify for a patent because originally, if you recall, it was actually designed. It had some medicinal qualities and maybe involved some illegal substances.
Right.
But there's nothing else it qualifies for. It's not. When Mr. Coleman talked about copyright, it's not that because it doesn't have. It's not an expression. It's a liquid.
Right.
It's not a trademark. It's maybe a patent, but probably not. It doesn't help you do anything. And so all that's left is trade secret. And so probably one of the most valuable brands in the world has everything locked up in this trade secret, which it can keep forever as long as it doesn't publicly say, here's the recipe and here's how you make it.
Okay, so we'll stay on that one just for a second, and then we'll probably move to copyright and trademark being probably the most relevant in a day-to-day. So would you say that, so like a trade secret like Coca-Cola, how do they enforce that? Like, does Coca-Cola just, if they found out some random person, is that done through, like, how does that legally get found out? How does it get disputed? Like, what does that process look like?
It's a series of different ways. It kind of depends. So the first three we talked about are all federally regulated.
Okay.
You have the U.S. Patent and Trademark Office, then you have the Copyright Office, and they are following federal statutes and enacting their own regulations. Trade secrets are done state by state. So the answer first depends on what state are we in. We're in Florida, so we have a Trade Secret Act in Florida. And this allows, if the company can prove that what you did was steal your trade secret, you can go after them for injunctions to make them stop. You can make them pay fines. You can cover your attorney's fees to get them there. But the other way that's, I think, more common is confidentiality agreements. I mean, if you're trying to prevent, usually it's an employee, a disgruntled employee leaves, takes something that was critical to your business and goes to your competitor and says, don't worry, guys, I know exactly how to do this.
Right.
That's a contract issue. And it's most effectively handled that way. But Florida has a separate statute that can handle trade secrets, and that's fairly common litigation.
Okay. Wow, interesting. Well, I'm going to share this out real quick. I forgot to do it at the beginning of the show, but while I do that, I'm going to kind of try to multitask and ask a question. So I wouldn't be doing all of our followers any justice if I didn't ask about kind of what the culture that we're in right now of like government-wise and our trade war that we're having with China. And that one of the biggest issues with China that we're having right now is that they're stealing a lot of intellectual property. Obviously, it's a different country, so there are laws. You said they're federally regulated. How does that fall in, and how, like, what? Not saying you guys have to give like a legal opinion, but like, what is your solution? Like, how does that? Like, what is the best way to get China to follow? Not steal the stuff that we're creating. Is that an okay question to ask? I don't know if I don't.
Sure.
I don't want you guys. All right.
I'll kind of shoot off, and then Zach, if you want to.
I'll do color commentary.
Yeah.
Interrupt him.
So the first thing to remember is, as manufacturing, pretty much a giant at this point, that's one of the things that affords China the ability to create a lot of these knockoffs, which is what they're doing. What they do when they create intellectual property theft is they either create the same product and change the name or change the logo, dilute the brand, or they actually resell it to other countries in the United States as a knockoff product. But when they're doing it in the same manufacturing plant, it's a lot easier to change the name, move coach and make it title it with a K instead of a C, those kind of things. When you're making the same or substantially similar product in a manufacturing facility, or just any manufacturing facility, I would posit, and this is pretty much just a personal opinion, that the more manufacturing a country does, the more ability it has to create knockoff products, because it's creating more products, so it's going to have the ability to create more knockoff products. From China's perspective, while they are party to some of these treaties that require them to regulate and enforce intellectual property, the enforcement mechanism is not widely utilized. So they're not essentially really enforcing it the way that they should be. Now, it's interesting, though, they will enforce their trademarks and their copyright and their intellectual property different than they will pretty much enforce foreigners or other like large multinational intellectual property regimes. So, for example, there's this thing called the Madrid Protocol. So if you want to register your intellectual property, specifically your trademarks, abroad, and that covers a lot of the countries in the European Union, then you might sign on to the Madrid Protocol and actually have your trademark registered that way. So you go through a particular process with the United States, and now it's protected with the United States, Mexico, Canada, and a lot of the European Union, and it should be also protected in China, but they don't enforce it the same way as they do their trademarks. So a lot of specialists, a lot of different attorneys will actually recommend, if you're doing a global trademark or you're trying to create a global brand, that you actually trademark in China with a Chinese attorney and go through their process for their intellectual property, and then also do it for all the other countries as well.
If you're doing a lot of manufacturing over there, it makes a lot of sense. I mean, you may not be selling in China.
Right. Well, it also makes sense. Well, and so if you don't know, if you have a company in China, even if you're doing business in China, you open, like say Starbucks opens in China, China then owns a percentage of that store. And so China, if they enforced all of like the intellectual property being stolen, then they lose money. So I think that that's another reason why, and you know, we're just trying to figure out how to get them to do it.
Absolutely. I mean, an knockoff industry is still an industry, and so they're still going to. They're going to have to devote additional resources from the government to enforce those trademarks. So that already takes out more money from the government's coffers.
I think it's some part of this conversation is a bit of a pay grade a little bit, because they're enforcing their own trademarks,
right?
And so that they're paying enforcement costs. And I think that the simple answer is usually the right answer, which is if they're enforcing their own trademarks, playing in their sandbox, applying for a Chinese trademark is what makes sense. I mean, I think if you're a business owner and at the end of the day you don't want to spend a ton of time, I mean, any one business owner doesn't have direct control over national, international politics. So what can you do to play in better is register in China.
Yeah, follow their rules.
I mean, so at the end of the day, these are all law is sort of just this general fiction we all agree on. And so none of our rules are going to apply in China. And so they have their own rules, apply for their rules. I mean, to me, it seems like a fairly straightforward way to handle that.
So why do you think everyone's making a big deal about it? Just because are they being like just crying to mommy because there's something their toys being taken away, or?
It's hard to know. It's hard to know what the exact reason is. But I mean, certainly they did sign the Madrid Protocol. They did agree that they would follow these rules.
And then they're not doing it.
So presumably that would be the reason why people might be a little bit frustrated with it.
It kind of becomes, perhaps a argument about a slippery slope too, because the argument is, well, China's just not playing by the Madrid Protocol rules, so we're going to go ahead and spend the extra money, because it's extra money and extra time to go through and register it in China. Now, what is to stop France, Germany, Spain from all saying we're signatories to the Madrid Protocol, but you're just better off?
The answer to that is comedy. So, if you're France, the reason why you want to follow the Madrid Protocol is because you want to make sure that your business owners, because their brands are protected in the other Madrid Protocol countries. I mean, I think nations have a lot of incentive to follow the Madrid Protocol because they have patrons. These politicians have patrons who are business owners, and these business owners have a vested interest in their trademarks being enforced internationally. And so I don't think that there's this issue of, well, if China's not going to play, then France isn't going to play. Well, then if France doesn't play, then people may not enforce France's trade. Right. So that's a huge cost to France. It's just that China doesn't seem to care about that.
Right.
So everyone's playing nice, and then there's kind of the bully out there.
They've just decided there's more leverage in not playing the game. Right. But I think Zach is right. A lot of the other countries look at it and say, I would then be restricted from access to other markets, so I don't have that same kind of leverage. They've just decided their market's big enough to just play in their own sandbox.
Yeah. Wow. So super interesting. Let's see. Is there some way to compel Chinese corporations? Oh, I'm really close to the mic now. On international trademark without going through China's trademark system, or is it just too costly to do that? So they're saying basically, is it worth doing what you're saying, which is play by their rules, or is it too costly?
Well, I don't know what the exact registration cost would be in that context, so I'm not sure I can answer that question.
Yeah. All right. Well, let's move on a little bit from that. So let's talk about why do people care about trademarks? Like, are they valuable? What are they worth? Like, how do I know that? I actually heard a podcast this morning that they were talking about like Ford, that during the financial crisis they actually used their emblem as collateral for a loan to kind of get them through the financial crisis.
So trademarks have pretty substantial value. Forbes did an article recently on what were the 10 most valuable, and every single one of the 10 was valued at over $25 billion. So, and some of them were valued over 40. I believe Google is valued at 41 billion, somewhere around there. And so, the trademark itself, and this is not a physical thing. It's just the right to say that this is a Google something is worth about $40 billion.
Wow. So, I mean, like Google created their own like home, or I guess they may have bought it, but that Google Home is worth, because it's called a Google Home, that use of Google is
presumably, the idea behind trademarks has always been it's that there's value in a brand. That if you know the company, you can trust the company, and so you'll pay more for something if it's branded. And you can see this. There are websites that sell unbranded products, and their whole shtick is don't pay for the brand.
Right.
You just want a spatula,
right.
And here's a $3 spatula, as opposed to a $20 spatula made by a brand spatula.
Right.
And so it seems to be, from a common sense standpoint, you can see this all over the place. There are off-brand clothing, on-brand clothing. You tend to pay more for the brand, and it's something to do. The idea behind the Lanham Act, which is the Trademark Act, is that there's a quality issue, and it's essentially a safety and a quality issue. If you know who the brand is, you can feel safe and you can trust the brand. And so if you assume that you would pay $3 more for every shirt that has a trademark on it, if you scale that to how many shirts they're selling, this is how they arrive at numbers like $40 billion.
Right. So, for example, like if you were to buy a brand name, oh yeah, hey Amy. So if you buy a brand name, are you assuming that, is there just an assumption that because, say, Nike, that you're buying a Nike shirt, that it's a better quality product? Is that what you're assuming by, or is it just that like they're also taking into account that Nike's so well known that they're valued? Like, where's the balance?
I think it kind of depends on what company we're talking about. I think some companies, their brand is cheap.
Right.
JCPenney's brand is
low cost.
Yeah, if it says JCPenney, then you know that you didn't pay too much. It's not somebody else's trademark, I'm sure. But
so can you assume that the most noticeable, like if you see a logo and it's the more recognizable it is, the more value is put on that product?
Yes. And especially, I think it goes to, not only that, but like what you associate that brand with. So, for example, Zach makes a perfect point about Sears or JCPenney's may not have the same brand recognition or quality of brand recognition as Gucci, Louis Vuitton, Coach, etc., Maserati. I mean, just to give a couple brand ideas. And what those people are saying is they're focusing on the product, but they're really saying to themselves, they're assuming the quality of the product from the brand that they're buying it from. They're saying this brand only produces quality product, so I will buy that brand and I'll make the assumption about the quality after the fact. I will buy a Tesla and say it's a great product if I am personally invested in the Tesla brand.
Right.
It also kind of helps you identify who to sue if you need to. So if you may they're not all brands are quality brands, and you may be okay with that. You may say, like, I know that this isn't a very quality brand, but I'm purchasing it. But what the trademark guarantees, and this is a big part of it, is it guarantees that you know who made it, so you know what to do about it if you were to be harmed by this product. So if you buy if it says Clorox bleach and you buy it and you bring it home and you open it up and these fumes come out and they kill your dog, presumably you have a products liability case here. And because of the trademark system, you can be sure that it's Clorox. If we didn't have a trademark system, someone could see, oh, look at that, Clorox is selling a lot of bleach, so I'm just going to start bottling up toxic chemicals and put them in bottles and sell them. And I'm going to call
it keeps
Clorox.
people from tampering.
That's the safety part of it. And so it doesn't necessarily need to be the fact that it's a high quality.
Right.
It's just that it is some quality.
Yeah.
It's kind of like crystallizing the marketing. They're spending
control.
A ton of money on marketing, and where that value gets retained is in the trademark itself. And so the way they market themselves, so Gucci markets itself to a very particular high-end space. Gap does not. But it doesn't mean that it's a worse or less trademark. It's just the Gap, that what they want to capture is, hey, this is a reasonable clothing brand.
Right.
And if you're a reasonable person.
Interesting.
It also allows you to centralize, not just from a lawsuit, but from a complaint standpoint. If you have a complaint about a Gap, or a Levy jeans. Let's call it. Let's go with that. A jean company. You can go to that company. You can go online and say, I had these jeans and they're not great, or I had these jeans and they were wonderful. And then those people can kind of they can come back and say, oh, well, that's too bad. Or they could say, we're going to really look into this. We're sorry that this happened to you.
Gotcha. Quick question, then we're going to move on to something else, just real quick. We're already at 25 minutes. So this is something that's relevant. It made me think about it. So I don't know if you heard the story, but there was a kid who got bullied, was a big Tennessee fan. For college day, he made his own T-shirt, right? And it had the T on it from Tennessee. It was drawn on. Well, Tennessee decided that they would make a shirt about that. So they made a shirt. They gave him a scholarship. It's a big story. Who has what in that? Like, how does that get worked out? Does he have a copyright on that? Is he deserving of anything other than just that they offered him a scholarship? I mean, he's in fourth grade. So, like, how does that play in?
Joey, I take it familiar.
I am familiar with the story. I mean, it's really heartwarming what they did there.
I know. I'm not trying to take away the emotion of it. It's a super great story, but it made me think of it. There's a lot of different.
Well, first, let's break it down. The trademark of UT is owned by UT.
Assuming they've trademarked it.
Assuming that they've trademarked it, which I'm making that assumption.
Yeah.
So they own that trademark. However, his design, this is perfect. I'm glad you brought this up because it illustrates that distinction. So they own the trademark to the brand of Tennessee, of that school, right? If they have a trademark. Now, his particular design is copyrighted, and it's immediately copyrighted at the time of fixation. So as soon as he created the design, he had a copyright. If he wanted to enforce it, he has to register it. There's a process by going back down that way. But really, what it gives him is it gives him the exclusive right to distribute it and to create derivatives of it. What most likely happened in this scenario is that with the scholarship and the other things, they ironed out either a licensing agreement or an assignment agreement.
Gotcha.
Because copyrights, like any other version of property, though it's a little bit more abstract, you can still sell it and rent it. So selling it is assigning it and renting it is licensing it. And so they either probably worked out an assignment or a licensing deal where they gave him the scholarship or extra money in exchange for being able to use it.
And so another example, of like licensing would be if you buy anything that has your team's logo on it that isn't the NFL brand or really even the NFL brand, the teams are licensing to, and that's basically renting out the ability for them to use it. So whether it's a Nike Polo or a Tervis tumbler or a Yeti cup, they're all licensed, renting out the ability to use that.
These are huge revenue centers for the teams. So they get to turn it. Tervis is paying them for the right to do that. And so when you're looking at balance sheets for companies, you can see the licensing income coming in. And so if you're the Patriots and you've got a deal with Tervis, you don't have to make these cups. You can just sit here. You've developed your brand value just by winning a lot of games, apparently. And now people are willing to pay you to put your stuff on other things. And this is a fantastic situation to be in because you're not the manufacturer.
Right.
The Trump organization actually does a really good job of this. They almost don't own any of the buildings that they actually have their name on. Trump, when he was part of that organization, was basically licensing out his name on these buildings. He didn't own the buildings; he just owned the license, and they were paying him to basically make it seem like it's a thing about high stakes, about luxury, etc.
The very pedestrian example of this is franchise agreements. So, like, this was how McDonald's originally expanded so quickly. They didn't have the cash, and they couldn't get the cash to build McDonald's in every state. And so what they did was they set up a licensing deal where they came into these companies. You as the franchisor would come in and enter into agreement where you get to use their name, and and then they're going to tell you exactly how to run the business, and you can be pretty sure it's going to work because it's working
quality.
there.
So that's how they keep quality.
You have to go do the capital, buy the building, buy the real estate, and you get to use all their licenses. And so, I mean, there's a massive application of this kind of stuff.
Okay, wow, super interesting. Hope you guys are enjoying this. Real quick, we're probably going to go a little bit longer than we normally do today just because I do want to touch on copyright. So this would be, and I know that it gets really, really layered with songs and the artists that then cover it. And if they then get popular by that, there's like levels of it. So do you want to give just a quick example, maybe that can kind of cover a little bit of how copyright, like in today's world, example of like kind of the layering of the copyright and how it affects us? Sure.
I'll kind of start, and then Zach, you want to?
Color commentary.
Color commentary. So in the music space, there's really we're really talking about two different types of copyrights. And the best example of this is actually Africa by Toto, and then the new example by Weezer. There's an underlying musical composition. So in both of those songs, those recordings, they're actually using the same musical composition. They're using the same song. So that's a music composition copyright. In addition, each one of them, both Toto and Weezer, have a copyright, or their companies would have a copyright in their own recordings of the underlying musical composition. And that's a sound recording copyright. So those are two separate things. What we're seeing a lot in the music space right now is samplings and mashups are kind of interesting because they are using both. I mean, they're using the sound recording, and then if the sound recording has to rely upon the underlying musical composition. And they're using a bunch of those. So for example, Girl Talk and some other like large-scale artists are basically putting all these songs together. There's been a lot of litigation in this area, but not necessarily recently. And the reason is because twofold. One, a lot of artists don't want to sue their fans who also like those mashup artists. And the second thing is that they're really concerned about what's called transformative use. So in the copyright, even though you may be infringing or violating a copyright, there's certain exceptions that fall into non-infringement, and that one of them is fair use. Basically, if you're using it for educational reasons, actually, what's really interesting is the Copyright Office just codified weddings and other religious ceremonies. If you're using songs, you're fine. And transformative use, where you take the work and you make it so different that it's now a transformative work. One of the examples I would give is, The Wizard of Oz. It is in the public domain, but then there's a new theatrical, it's not necessarily new anymore, but there's the theatrical production of Wicked. Well, that's a transformative use on an original product. And I think that if they had an issue, which they didn't, then there might have been an argument about using that as fair use. So that's why we see a lot of people right now doing mashups and things like that and not having those issues. And the reason they're not having those issues is because A, of the PR, and B, because they're concerned that there will be a lot more mashup artists if that actually goes to trial and a court determines that this is actually fair use.
So how do I use Taylor Swift's song if I want to put it on my Instagram? Like if I want to post a video and I want to use her song as a background, or I want to do another Facebook video and I want to put it on the background, how do I have to ask her permission, or is it she has to come after me? I know she has to cut. Well,
so when you're playing songs, this issue first came up somewhere around the 1920s. There was this issue of so the copyright gives you 6 exclusive rights, and one of them is to perform the work publicly.
Okay.
And so initially, you got to remember the Copyright Act is the first draft of this is written before recorded music is really a thing. And so in order to perform it publicly, the artist would have to be there. So it was really easy to monitor when the artist was performing the work publicly.
Right.
As soon as the first movement was actually player pianos, as soon as the player pianos show up, we've got this problem because we've got these player pianos in these restaurants and these places that are playing these songs like Scott Joplin's and this is creating all kinds of issues because how do we track this?
Right.
And so these organizations cropped up called the performing rights organizations, and this will be something that will change the way you walk around the world. When you see stickers on buildings, you'll see ASCAP and BMI on like restaurants and bars usually. Uh-huh. Those are the performing rights organizations. Those are the primary two. There's a couple others, but those are the primary two. And so these organizations are monitoring radio stations and bars and the internet and listening for plays of that song. And then they're paying the artists and they're charging the bars and the venues and these sort of things. Wow. Now, but your question, I actually didn't answer your question
no,
at all.
That's okay.
Because your question is difficult because it wasn't, we're sort of in this interesting, it's almost like an inflection point in copyright law where it's so easy to create and publish content right now, and for the past couple of years, this has been the case that copyright law cannot move fast enough.
Right.
Technically, she has an ability to stop you if you put a toast in this song because there's a specific right for synchronization licensing. So if you're just playing the song, then she can't stop you, but she can charge you. In the video space, music has a special protection where the artist can actually say, no, I don't want to be associated with this. And the common examples of this are politicians that they don't support using their songs to support these things. And then you can also imagine much more seedy examples they wouldn't want to be involved with or associated with. And so they can actually tell you no. However, we have coming up against a practical wall, which is how many videos get uploaded to YouTube every single day, how many get uploaded to Snapchat and then disappear. Were they there long enough to be an infringement? Instagram, same thing with their daily stories, they disappear. So there are so many questions here, and I think honestly there are not a lot of answers. And I think what's going to happen is kind of like the first big shockwave that hit the copyright law space was Napster. It was all of a sudden this realization that, wait a second, there are infringers everywhere.
Everyone's downloading music legally.
And it became this just giant crisis, and there were lawsuits everywhere, and there weren't a lot of answers. But then that one kind of shook out, and we decided that there were answers, and because it was very simple to understand. They were taking the song, they were downloading it, and they were taking it. And then they had a copy of it. But now we're in this space where people don't tend to have things. If you really think about what you own anymore, you own less than you may have before. People don't own a CD collection. You're not burning CDs.
You're just streaming.
You can send on Spotify. I can send you a link. I'm paying for a subscription. You're paying for a subscription. That issue's gone now.
Well, you own access. I mean, that's really kind of a lot of our generation is not about the ownership, but the ownership to the access.
Well, and really, you're just renting the access.
It's licensure. And so I think that, so the really roundabout answer is it's probably not okay. But I think that and there's not really much of a way around it because it's not like Taylor Swift's going to, and this is no personal slight, but I doubt that she's going to be willing to entertain negotiations with you in a meaningful sense.
I don't know.
But, I think that's where we need the viewers to really step up. This show needs Taylor Swift on it. Because we need to ask her personally what we're going to do about this song.
Taylor, if you're listening, we want to know how you feel about it. Well, then it goes back to...
It's not if you're listening. Taylor.
Yeah, obviously she's listening. She's a big Finance Friday follower. So, but then it goes back to if she decides to go after her fans for using her song. So it kind of comes full circle. But
one of the ways, by the way, that it's kind of getting solved by... So the musicians and really the labels, the publishing companies have a big incentive to stop this. And so and one of the things that they said, so their initial approach was fight back, sue the infringers. The new approach, which is much more, I think, intelligent, is let's figure out a way to provide legal options. And so you'll notice there's a lot of integration now in Facebook and Instagram with Spotify directly. So that, the song's there, but it's coming through Spotify. And if it comes through Spotify, then everyone's been covered. And so there are more legal options now. And so maybe this little pocket of infringement that we're all experiencing right now, this may not even be a thing in 5 years.
But it's interesting you say about, a whack-a-mole. That used to be the problem, but as we've started to see, for example, with YouTube, they have this thing called the Content ID system. And so what's happening is a lot of artists, major artists, are uploading their songs into a Content ID bank, and then the computers are basically solving the problems for them. The computer can immediately just tag every song where it recognizes that song, and then let the artist know, hey, I've got 10,000, 100,000, 52,000 songs. Which ones would you like me to take down? Which ones would you like me to take a part of, like a portion of the proceeds for? And which ones would you like me to leave alone?
Interesting. That's crazy. Well, I think that is probably enough for today. We could probably keep going on for another hour. But thank you guys for coming today. We also we'll probably have them back another time. Taylor, reach out, let us know when you want to be on the show, and we'll look forward to seeing you next Friday, Taylor. But everyone else, have a great weekend, and we hope you have a great weekend, and we'll see you next week. Bye. Still on. Here we go.